You're welcome. This is GH Today on GHOne Television. I am Sewami here, and it's time for Heart Talk. This morning on Heart Talk, we're bringing you an exclusive interview with the Venerable Tsatsu Tsikata, who needs no introduction at all. I mean, what more can I say about a man that I've been reading about all my life since I was a child? The legal colossus, and simply put, a statesman. Good morning. It's a pleasure having you.
Good morning. It's a pleasure to be on your program. My first time at GHOne.
How have you been?
Very well, by God's grace.
You look very healthy.
Health is wealth, isn't
Right.
it? So
How do you keep yourself in shape? How do you look so healthy even at your age?
well, who told you I was that old? I'm still young. So
You're still
don't
young,
worry.
huh?
In my 70s, I'm still a young man. And I think by the grace of God, I have remained relatively young. So I believe I'll continue to be young.
What do you do? How do you do it?
I pray.
Okay.
I exercise a little bit, not as much as I should be. I'm not as disciplined in my exercise as I should be. But as I say, I pray for God's continued grant of good health. And I think that enables me to earn His grace.
Okay, Mr. Tsikata, I mean, regularly meeting you, I would have wanted to know a lot about your life and what you have been doing, what inspires you and whatnot. But I want us to get into it because we have just a few days to election 2024. The biggest legal issue right now in the country is the action that was initiated by the Member of Parliament who happens to be the leader of the Majority Caucus on the interpretation of Article 97G and H. I just want to know what your thoughts are on all of these things happening in the country.
Well, I think we should look at all these things with the seriousness that they deserve, because as citizens, we have responsibilities to make sure that the Constitution is respected by everybody, all arms of government, everybody. And so I think when we look at what happened in the Supreme Court in terms of certain orders against the Speaker of Parliament, and then the Speaker of Parliament trying to set them aside, there are a number of problems around what has happened. Because first of all, orders were made against the Speaker of Parliament without his being invited for his side of the story. Honorable Afenyo-Markin, who had been affected by the Speaker saying that based on certain people vacating their seats, he was no longer majority leader, ran to the Supreme Court. In fact, he ran to the Supreme Court before the determination.
That announcement was made by the Speaker.
But he ran to the Supreme Court. He asked the Supreme Court by writ to interpret the Constitution and so on. And then he also filed a motion for an injunction on notice. So that motion would have had to be served on the Speaker, according to what he himself filed. Then, I believe the next few days, I think he filed on the 15th. Then, on the morning of the 18th, he files a motion, this time without the Speaker's participation. And the motion is called a motion for stay of execution of the Speaker's ruling. And he files it, as the records show, something like noon. And I mean, normally everybody knows that when you file anything in the Supreme Court, the registrar, will have to set a date and so on, because the Chief Justice will now have to empanel the court. Somehow, the Chief Justice was able to empanel, and apparently by 2 o'clock, the court was sitting. And not just the court sitting, but the court proceeded on the basis solely of what was put before them by Honorable Afenyo Makin and gave orders in terms of what he put before the court without any, anything being heard from the speaker. Now, this raises very, very serious questions within, constitutional system. I mean, first of all, the idea of asking for a stay of execution of a ruling of the speaker, there is really no legal basis for a stay of execution of a ruling of the speaker. The court, the Supreme Court and other courts, have the authority to stay execution of decisions within the court system.
Okay.
But you don't apply for a stay of execution of something that happens within another arm of government, which is the arm of the speaker. Now, the impression was given that because this is a matter for interpretation and so on, therefore you can run to the court. But again, there are clear decisions of the courts themselves, including the Supreme Court, decisions which make it absolutely clear that you don't, under the guise of interpretation, take to the Supreme Court things that are within the preserve of other courts or other authorities in the system. Very clear decisions. And I think we have to have a little law class here because I like some of these passages from the decisions of the Supreme Court itself, to be laid out for all of us to look at, because all of us have a responsibility to protect what is in the Constitution. The Supreme Court is not a law unto itself, fortunately. Neither is the Speaker a law unto himself. We all have responsibilities. So when, for instance...
Would you then say that the Supreme Court erred in that?
Well, definitely, in many respects. In fact, as I will try to perhaps explain if there is time, it erred in multiple respects. As I said, in the first respect, just running and saying there's a matter of interpretation, therefore Supreme Court, I'm before you, is not acceptable. The courts have said in many cases, there's this case, for instance, Eduamoa and Chum, where it was stated, Aqua, the Justice of the Supreme Court, as he then was, makes the point that all courts, tribunals, institutions, and all individuals are bound by the provisions of the Constitution in the adjudication of disputes before them. In summary, then, whereas the original jurisdiction to interpret and enforce the provisions of this Constitution is vested solely in the Supreme Court, every court and tribunal is duty-bound or vested with jurisdiction to apply the provisions of the Constitution in the adjudication of disputes before it. And this jurisdiction is not taken away merely by a party's reference to or reliance on a provision of the Constitution. So just running to court and saying, Supreme Court, I want you to interpret such and such for me, does not mean that the Supreme Court should go ahead and do that. The Supreme Court has to decide whether it has jurisdiction. And I'll give you another example of something that
But I thought that interpretation of the Constitution is the exclusive jurisdiction of the Supreme Court.
Yes, but the court itself has made it clear that that does not take away the responsibility of others to apply the Constitution. Every institution, every court in the land applies the Constitution. Right. In applying it, they have to understand it. They have to interpret it in that sense. So the courts have made it quite clear that when you talk about the exclusive jurisdiction to interpret, it is not everything about some provision of the Constitution that leads to the requirement of interpretation. Do you see what I mean? So
there has to be some parameters that has to be met.
Exactly. And those parameters have been set out in judicial decisions of the court itself.
Right.
And basically, those earlier decisions of the court itself.
I think it's ex parte accusa.
There are many such decisions. Right. That's exactly one of them. But there are even more recent decisions, like when the Ghana Bar Association tried to take Chief Justice Aban's matter to court, and they tried to say that Chief Justice Aban should not be a Chief Justice because he did not meet certain moral standards and so on. They took it to court. And it's interesting what the Supreme Court said in that case. Because, in fact, in that case, they made very specific reference to the fact that Parliament should not overstep, the Supreme Court should not overstep its bounds, especially when it comes to parliamentary matters.
So, Mr. Tsikata, in this instance, I know that you're trying to find the
Yes.
judicial decisions for me.
Yes.
But in this instance,
Yes.
where it appears that there's some misunderstanding, for the want of a better word, on what the provisions of Article 97 G and H means, what would you have had the Speaker or even the members of Parliament do?
Yes, let's go step by step.
Okay.
I'm saying that the Supreme Court, when it is faced with a matter in which somebody runs and says, interpret,
Right.
they don't automatically say there's an issue of interpretation.
Okay.
The court is guided by its own precedents,
Right.
in which it talks about what qualifies
An interpretation.
invoke its exclusive power.
Okay.
And they make it also clear that other courts also have the responsibility to apply the Constitution. And of course, in applying it, they also do something that you can call interpretation. But when we talk about the exclusive jurisdiction, it is based on certain parameters. So here's one of the statements that was made in the Supreme Court in respect of the Aban matter, for instance. The statement was made very clearly in the judgment of Justice Bergan. He makes reference to another earlier decision of Chief Justice Archer, in which Chief Justice Archer, as he puts it, came out forcefully in support of separation of powers and the principle of non-justiciability of certain matters in these words. The Constitution gives the judiciary power to interpret and enforce the Constitution. And I do not think that this independence enables the Supreme Court to do what it likes by undertaking incursions into territory reserved for Parliament and the executive. This court should not behave like an octopus, stretching its 8 tentacles here and there to grasp jurisdiction not constitutionally meant for it. So this was what one of the judges said. There are other statements in that case by other judges, all pointing to the fact that the Supreme Court should be careful in not venturing into the territory of others. Now, so when the Supreme Court, without even giving notice to the Speaker, so that the Speaker can at least let his side of the matter be heard, when it does that, it's very problematic. And the Supreme Court, again, has itself said that when there are previous decisions, it has to go by them, because that's what the Constitution provides. Article 1293 of the Constitution. There again, very clear. The Supreme Court is bound by its own previous decisions. Unless it wants to depart by stated reasons, then it can do so. But here, the court did not even make reference to any of these previous decisions because, frankly, they did not give the Speaker a chance to put before them his side of the case. So based on Honorable Afenyo-Markin's ex parte application, as we call it, they made those pronouncements about the orders. Now, those orders are also very problematic because when you look at the writ that Honorable Afenyo-Markin put to the Supreme Court, he wanted an interpretation of 97(1)G. You talked about G and H, but in his writ, he actually did not say G and H. He said G.
Right.
So H, which is about Honorable Esiama, the Deputy Speaker, was not part of what he took before the Supreme Court. People lose sight of that.
Right.
Now, so if he took G to the Supreme Court, the Supreme Court had no basis for bringing in orders in relation to H,
Right.
because that's not part of the writ. Additionally, as I think was pointed out by counsel for the speaker when he tried to set aside the writ, you have a situation where the papers that were filed by Honorable Afenyo-Markin were deficient in terms of the rules of the Supreme Court itself, because the rules of the Supreme Court required Honorable Afenyo-Markin to have an affidavit that verifies the statement of case that he filed. Because an affidavit involves somebody stating on oath certain facts, and on that basis, the court can act. In this case, there was no affidavit. So all that was in the statement of case lacked verification. And essentially, when the Supreme Court in its ruling was talking about things like constitutional crisis and so on and so forth, it was relying on things in Honorable Afenyo-Markin's statement of case which had not been verified. And therefore, they could not be relied upon as evidence before the Supreme Court. And when you have clear rules which require that for such an originating process, you must have an affidavit, again, there is judicial precedent for insisting that in those circumstances, the proceedings are void.
Right.
So they should not have proceeded without at least taking account of the fact that there was a deficiency in terms of compliance with their own rules. So that, again, is a problem. As I said, there are multiple reasons.
Problems. But forgive me for taking you back just a little bit. You talk about invoking the exclusive jurisdiction of the Supreme Court to interpret certain clauses in the Constitution. Are you saying, with the precedents that you give out, that even in this matter, that jurisdiction had not been invoked?
It had not been properly invoked by Honorable Afenyo-Markin's writ before the Supreme Court.
Okay, so then takes me back to the question that I asked you earlier. What would you have had them do?
What would the Supreme...
What would you have had Afenyo-Markin's, for instance, and the Speaker do?
First of all, the Supreme Court, I believe in this context, using its own rules, should have pointed out to Honorable Afenyo-Markin that there was no affidavit verifying the statement of case that he had filed before them. And therefore, his writ was deficient. And they could not proceed on a deficient writ. I think that would have been a simple end to the matter. Secondly, if the Supreme Court wanted to give any guidance to a plaintiff who has not complied with their rules, they would, again, just refer them to the rules and give them the opportunity, if they thought appropriate, to correct those. Because, again, there are rules of the Supreme Court which make it clear that non-compliance shall be a bar to further proceedings unless the Supreme Court waives that. There's nothing in the record which tells us that the Supreme Court waived anything by way of, sort of dealing with a non-compliance that there was, just on the face of things. So then the reason all these things are important is not just because of technicalities. The reason these things are important is because the rules enable us to ensure that things are done properly in an orderly fashion, and that whatever then comes authoritatively as a pronouncement of the Supreme Court is an appropriate authoritative decision that we can all go by. But where we see so many errors in terms of how the proceedings have gone, it just undermines the authority of the Supreme Court. And, this is really important because, again, as I said earlier, all of us have a responsibility to respect the Constitution and to ensure its enforcement. So, for instance, if you go to Article 3 of that very Constitution, it makes it quite clear that if any attempt is made to go against the Constitution, we all have a duty to resist it. And that attempt can be made not just by people wearing military uniforms, it can be made by people wearing wigs and gowns as well. So we really have to take seriously our responsibility, all of us, to be familiar with what the Constitution provides. The Constitution is not just some arcane set of words that lawyers can, indulge in and that judges can make pronouncements of. The Constitution, is the supreme law of the land, and it's very clear in the Constitution, for instance, that the exercise of that judicial authority itself is on account of the sovereign will of the people, which is embedded in that Constitution. So these are really serious matters, and I think that it is sometimes too simplistic for people to give the impression that the Supreme Court has made a statement and therefore, you have to go by it before you complain and so on and so forth. In this particular case, as you know, the Speaker actually took the opportunity of having his counsel go and try to set it aside.
And when he made the attempt to try to set it aside, the Supreme Court affirmed its earlier decision.
Yes.
And I'm sure that you have heard persons like GHOne speak that they were going to cite the Speaker for contempt because he is not obeying the decision of the Supreme Court.
Well, I would like to see that application by Mr. GHOne, Honorable GHOne. I'd like to, he was a student of mine too. So I'd like to see how his legal professional caliber stands up in terms of whatever he puts as in terms of contempt of court. But you know what?
But when counsel for the Speaker has tried to set it aside and he wasn't successful with it, shouldn't the Speaker obey what the Supreme Court said?
That cannot be the end of the matter, because as you know, for instance, there are rights to review a decision of the Supreme Court. So it can be the Speaker's prerogative to ask for a review. But you see, one of the aspects of what happened when the Speaker's counsel went to the Supreme Court to try to set it aside, one of the aspects which, again, is extremely worrying is that he objected to a member of the panel, Justice GHOne. Now, barely had he started raising the objection than, as we all saw on TV, the Chief Justice said, okay. And, so it's like he could not even articulate fully the grounds of his objection, except his first sentence about how Justice GHOne had been a parliamentary candidate or something at some point in the past. Now, there are many problems, again, with the way the Supreme Court proceeded there, because there's clear precedent that if an objection is raised against a member of the panel, that member himself cannot sit on the hearing of the objection. In other words, Justice GHOne, being a member of the panel which decided that he was not disqualified, is very odd. I had a case in the Supreme Court not too long ago where, on behalf of a party, I raised an objection to a member of the panel. That member of the panel happens to be the current Chief Justice now. I raised an objection. The court wanted that objection formally put. So we put it formally in writing. And the court constituted a panel which did not include her to hear the merits of that objection. And in the end, the court decided that she should be disqualified from sitting on that particular case. But in hearing the objection, she was not a member of the panel any longer. After we raised the objection initially orally, and the court asked us to put it in writing, the court was differently constituted. At that time, the Chief Justice was Chief Justice Eninyeboah. And so he excluded the person against whom we raised the objection. The same thing happened in the famous Salah case many decades ago. Everybody knows about the Salah case. An objection was raised against Justice Apalu at that time. And Justice Apalu did not sit on the panel hearing the objection. there was what was called a trial within a trial conducted to hear the merits of the objection that was put forward by the then Attorney General, Mr. Victor Usu. And in the end, the court that heard the objection heard evidence and decided that the objection should be should be dismissed. And the objection was dismissed, and Justice Apalu continued to sit on the Salah case. But you don't have the person against whom the objection is raised hearing the same matter about his own objection. Then he's being a judge in his own cause. I think you're a law student these days, so I'm sure you're familiar with all these expressions. And so, you know, unfortunately, I guess because of the haste with which the court was proceeding, a lot of missteps have been taken.
Okay.
And those missteps, I think that the court should itself find an opportunity to retrace its steps so that those missteps do not count against it in terms of the future records of the Supreme Court.
Okay, in wrapping up on this thing, Mr. Tsikata, as an officer of the court, you've been practicing for many years.
But I'm not an officer of this particular court because I'm not, I'm not appearing in this particular matter. But
generally,
as a professional.
Yes, generally. What is your understanding of Article 97(1)(g)? What if you were a speaker, what would you have done?
You know, in this particular case, I think that the speaker, from all accounts, made reference to an earlier parliamentary precedent. So, in a way, it wasn't the speaker doing an interpretation, but essentially relying on previous proceedings of Parliament and saying that this precedent is there and so on. I have not, I've not familiarized myself with the full details of the proceedings of Parliament that day. But from the reports that I've seen, the speaker was basically using a previous precedent within the parliamentary processes. So in that sense, if somebody is going to take on the matter, like I said earlier, then before the Supreme Court takes it up as really a matter of interpretation, first of all, it must satisfy itself that it's complying with its own rules about what it takes up when these interpretation matters are brought up. And secondly, it must be satisfied from what is brought before it by both parties that there's a real issue of interpretation. In other words, that there are two different interpretations. As it was, they really just heard one side, and even that one side did not verify its statements by an affidavit, and yet they concluded that there was an issue of interpretation. I think that what the speaker's precedent allowed him to do, following in the practice that the previous president showed, what the speaker's precedent allowed him to do was to say, look, the 97(1)(g), because that really is what the writ was about, it says that if somebody, I can't quote it verbatim, but it basically...
I can for you, that a speaker,
it says
if he leaves...
a member of parliament shall vacate
his seat
if
he leaves the party of which he was a member at the time of his election to Parliament to join another party or seek. So that's it.
Okay,
or,
so great.
Yes, if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent member.
Exactly. So basically, you have two members of Parliament in relation to whom this has to be applied. One of them had been elected a member of Parliament
belonging to a particular
party, the NPP. And at the time, that is 17th October, she sought to remain in Parliament as an independent member.
Did she?
Well, because...
Isn't it? Because they make the argument that it's for the
Yeah.
upcoming elections and
again,
not for the time that she's in Parliament.
But that's why I'm saying that those are factual matters that have to go properly before a court. And Article 99 of the Constitution also makes it clear that for the determination of those factual matters, it is the High Court that is given jurisdiction. Exactly as the High Court having jurisdiction in respect of a parliamentary election. So for the vacation of the seat, equally the High Court. And you know what is interesting? The Supreme Court again has made numerous pronouncements stating very clearly that these are matters exclusively within the jurisdiction of the High Court.
We will see.
You know, exactly. I'm glad I really see that you're going to become a very accomplished lawyer.
Thank
but
you.
there are many cases of the Supreme Court, including the Sal case. In the Sal case, for instance, it was the current Chief Justice who, during the review application, wrote a very extensive decision affirming the earlier decision at the ordinary bench and making it clear that the High Court has exclusive jurisdiction in respect of the matter of a parliamentary election being annulled. Equally, in respect of vacation of seat, which is also within the same 97(1)(g), the logic of that applies. And that is why, you see, I think the critical thing you have to remember is that for all those criteria that are set up in 97(g), factual determinations have to be made.
Okay.
And those factual determinations could not be made by the Supreme Court when there was not even an affidavit before them.
Okay.
So there was no evidence before the Supreme Court. I mean, I'm sorry, but these seem to me to be very simple matters, which, if we just take them calmly, a step at a time, we can all see that something is going amiss.
Okay.
And that thing needs to be corrected.
Okay. Now, there's one other aspect of this that I want us to tackle before we move on to the next conversation.
But can you allow me just to make one additional point? You see,
sure.
The Supreme Court also brought in 97(1)(h), which was not part of the writ. Now, so based on that, they made orders that included Honorable Esiama,
the second Deputy Speaker.
the second Deputy Speaker. The Supreme Court also seems to have missed the fact that I think the honorable member for M.anifest Central was not even named in the writ that Honorable Afenyo-Markin took to them. So there was no issue in relation to him that was being brought before the Supreme Court according to the terms of the writ. Honorable Aka, I think he's called, he did not feature in the writ of Afenyo-Markin at all. And yet the Supreme Court ended up making orders in relation to him and in relation to his constituency and the people that he represented. I mean, based on no factual evidence. And that is really basic and problematic.
Okay, but so what deduction then do you make of it? That even though this was not contained in the writ, it found itself in the ruling and its rippling effect?
I don't wish to make any deductions except to emphasize that I think the Supreme Court has the opportunity to correct its errors because they're so glaring. And I don't think that they enhance the stature of that court.
Okay, Mr. Tsikata, there appears to be what many call, battle of power between these two arms of government, the judiciary and the legislature, because it appears that Parliament or the Speaker doesn't want to respect, quote unquote, the decision of the court or the judiciary. How do we navigate out of it? Because, as the Chief Justice said, there appears to be some constitutional crisis, which the Speaker says there isn't, and so we should stop pressing the panic button. And it appears to be a back and forth.
Well, first of all, I think in respect of your point about battle of power, sadly, yes, there appears to be a power game going on. But fortunately, that is why we have a constitution. That is why we have a legal framework within which everybody should operate, whether the speaker, the chief justice, everybody should operate, the president, whoever, the vice president. And that is why you and I are having this conversation about what the Constitution actually provides, because it enables all of us to see the issue, not in terms of who has power or who doesn't have power, but in terms of what does the Constitution say, and our allegiance, all of us, should be to the Constitution, not to any power. You know, I should say, and I say this very respectfully, of all the powers that be, I think sometimes indeed the manner in which people conduct themselves, whether they're sitting as judges or they're sitting as Speaker of Parliament, the manner can convey a show of just sheer power, which does not help in terms of communicating, the supremacy of the Constitution. I think that we should all learn to communicate the supremacy of the Constitution. We are all under the Constitution. And so when, for instance, challenges are made to our actions on the basis of our non-compliance, we shouldn't see it as an affront to our power. We should see it as an opportunity really to consider whether, in fact, we may be upholding the Constitution or not. And if we're not upholding the Constitution, we should be the first, especially within the judiciary, because, you see, the judiciary and the legal profession, I would say, have an especial, I would say, privilege in respect of these matters about the Constitution and about the laws of the land. Because even though all of us as citizens are supposed to be conversant with the law and to obey it, and conversant with the Constitution and to affirm its supremacy, we don't all have the training in all the elements of the Constitution and so on. We don't all have that. So we as the legal profession, they as judges in the various courts, have I would say a privilege, not so much a power, but a privilege to enable themselves to be guided by the Constitution and to use it as a beacon for us as a nation.
Okay.
If we don't apply the Constitution in that spirit, then indeed it will appear that there's just a battle for power.
Okay. Ultimately, the Supreme Court is supposed to decide on the matter today, on the day we are airing the interview, which is Monday. What are your expectations?
I don't have any expectations because, as I've said, there's some things that are very glaring to me, but it also does appear, and I think, people have even talked about even the body language during the hearing, which was aired on television and so on. It does not appear as if there is much of a concern for these very important precedents, that some of which I have made reference to. And there are many more, by the way. There are many more of the precedents on the matters that I've talked about, which can be unearthed and brought to light. So if it appears that there isn't an interest in those precedents, that's a very dangerous signal for the health of our country, because, the Supreme Court is a body that we don't expect to set at naught its own precedents, to set at naught constitutional provisions. We don't expect that from the Supreme Court. And that's why I say I'm not in expectation of anything except a hope. I have a hope that the Supreme Court would, show a respect for the Constitution, for its own precedents, for its own rules of court, in looking at the matter that Honorable Afenyo-Markin has brought before it. There are many other deficiencies, by the way, in what Honorable Afenyo-Markin took to the Supreme Court, which all have to be taken into account. So, when you say that someone is talking about taking the Speaker to court for contempt and so on and so forth, the Speaker also has, within the Constitution, the power to hold people up for contempt of Parliament. So are we going to find ourselves in a situation where the Speaker is also going to have powers to commit for contempt, and the Speaker also uses or tries to use those powers? I don't think it helps anybody to have what you rightly called, a kind of power battle where everybody is trying to stand on their, sort of high horse. Because ultimately, when you do that, the country suffers, and frankly, I think your own reputation suffers. And I want to give an example of the way that the reputation of courts can suffer.
We will get into that after the break, because after the break, we're still going to stay on the court, but this time the image and perception of the judiciary. I'm seated here with the Venerable Tsatsu Tsikata. Stay with me. I'll be back with more after the break. Yeah, welcome back to the show. This is GH Today on GHOne Television. I am Sewami here, and I've been talking to the Venerable Tsatsu Tsikata. If you just joined, well, you missed a whole lot, because we've been talking about the biggest legal issue in Ghana, that is what's happening in Parliament, and we don't know when there'll be an end in sight. But we're going to move on to talk about the image of the judiciary. But Mr. Tsikata was going to make an example of how these things affect the image of the court.
Well, not so much how they affect the image of the court, but in a way how certain decisions of the courts which are not compliant with constitutional principles, constitutional provisions, in the end sort of backfire, and in a way the court itself does get discredited. So I'll give you the example of what happened in relation to the Honorable Member of Parliament for Aston North. In that situation, Gyakye Quayson's case, where again there was a High Court election petition, and the Supreme Court had said the High Court is where election petitions should be adjudicated and so on. The High Court had decided the matter was on appeal. That process was going on. Then the petitioner runs to the Supreme Court and says that they want interpretation and enforcement. And somehow, in that situation, unlike all the other precedents, the Supreme Court takes up jurisdiction. In fact, I'll tell you, the Supreme Court, even before it fully went into that case, they had before it, I think Mr. Frank Davis, a lawyer for the petitioner, went before the Supreme Court with an ex parte application, similar to what Afenyo-Markin did. In that case, the Supreme Court said, no, we can't proceed without giving a hearing to that Member of Parliament. So the Supreme Court actually did not proceed ex parte. They went on notice, and then in the end, they decided against Honorable Gyakye Quayson, on grounds which we don't need to get into at this stage. But it was not really a decision in compliance with the Supreme, the Constitution and the Supreme Court's own precedents. So based on that, an election had to be held. A by-election had to be held in that constituency. And guess what? Honorable Gyakye Quayson won by an even greater majority in that. Again, the Supreme Court's earlier interim injunction, the interlocutory injunction that they gave, was clearly related to attempts to pass the e-levy. Because with Honorable Gyakye Quayson in Parliament, the government was having difficulty in getting the numbers to pass the e-levy. So an injunction is obtained against him in the Supreme Court. He can't vote. E-levy is passed. What has come of the e-levy? The E-levy, I mean, the E-levy is a disaster. Even the candidate of the governing party for the next presidential election wants to stay far away from the E-levy, and is, according to what I'm reading, is saying that there will be
it will be abolished.
It will be abolished, and so on.
If he becomes president.
And the Supreme Court had been pushed into an interlocutory injunction against that member of parliament, which meant that that member of parliament's constituents did not have the benefit of his presence as a member of parliament for several months. I mean, the Supreme Court in this particular case is talking about these people and their constituents being deprived of being in parliament for the remainder of this parliament, which is barely a month or two. The people in Sao, the people in the South traditional areas, they have not had a representative in parliament the whole of the 8th parliament. And Supreme Court decisions have been involved in making that happen in the way that it has happened. And following the Supreme Court decision, the High Court also recently in Ho made a very strange decision. After the Supreme Court says the High Court is the place you go for that, the High Court said it didn't have jurisdiction.
Now that you have mentioned.
So basically, I'm saying to you that, in the end, these things backfire because the kind of political outcome that is being sought. In Honorable Judge Kwesi's case, everybody went and campaigned against him. The president, everybody, all the great hierarchy, of the government went to campaign against him. He won by a greater majority. So I'm saying that the people of Ghana, frankly, are also very discerning about what is going on, all these, sometimes machinations, because in the end, when they look at the situation, they end up not really feeling satisfied that what has happened, whether in the court or wherever, is the right thing. And so their voice will ultimately determine.
Okay, we'll come to Saul a little later, but I want us to look at generally the image of the judiciary. There are many people who have accused the NDC of undermining the judiciary. President Nana accuses John Dramani Mahama, AG Godfrey Dame, even the immediate past president of the Ghana Bar Association, has said that when the NDC loses a case, then they undermine the image of the judiciary. What do you make of these attacks? Do you think they are warranted?
Well, first of all, I'm not speaking on behalf of the NDC here. I'm speaking as myself.
Yes, I'm talking to you as a professional who has been practicing for years.
Exactly, for many years.
Many years.
So, I mean, I think that it is really quite naive for anybody to suggest that when you criticize a decision of the court, it is because or it amounts to undermining the court. I myself, as you recall, have been prosecuted. And when I was prosecuted in 2001, I took the matter to the Supreme Court. The Supreme Court initially gave a decision in my favor. And the Attorney General at that time, who is the president at the moment, said that that decision was a perversion of justice. I mean, I've forgotten all the exact words that he used. But basically, he went on an attack of the Supreme Court. And in the end, the president at that time added to the numbers of the Supreme Court and got a review which then overturned the decision that had been made and so on. Now, when people criticize decisions based on the objective facts, I mean, I've been talking to you, pointing out things that I see as erroneous in the determination of the Supreme Court. I don't think anybody can accuse me of undermining the Supreme Court. I am rather insisting that such discussion should enable the the Supreme Court to uphold the supremacy of the Constitution, to ensure that the Constitution's integrity is maintained. I don't know the specific instances that are being referred to where President Mahama has said something about a decision which is now being said to be undermining or whatever. So I can't get into those. But my point is that just because the NDC or somebody in the NDC criticizes a decision of the Supreme Court should not be taken to mean undermining. Equally, somebody in the NPP, as the Attorney General who was then president, criticizing the Supreme Court at that time, I wasn't about to say that it's undermining the Supreme Court.
Okay. All right. Still on the image of the judiciary, I'm sure that you have seen the recent Ibrahim Foundation assessment, which has dropped, or which says, that assessment says that judiciary impartiality has dropped by 30% from 2017, and that's what we have on the screen now, from 2017 to 2023. And I bring this up because I want to juxtapose it with statements by the National Security Minister, Kandapa, saying that Ghanaians seems to think that decisions are going a certain way by the judiciary. I mean, as a long-standing member of the bar and a practicing lawyer for many years, does this worry you that people actually think this way?
It does. It does worry me. It does worry me hugely for a number of reasons. First of all, maybe a simple selfish reason. You know, if people lose confidence in the judiciary, it is also a loss of confidence in the legal profession, in my view, because the judiciary consists of people who've come up from the ranks of the legal profession to their exalted positions as judges. And the more confidence is lost in the judiciary, the more confidence is lost in the whole process of adjudication, which is what, we lawyers practice in the courts. So I for even that selfish reason alone, I have a very deep concern. But more seriously, I have a deep concern about the country, particularly as you rightly point out, when you have your national security minister making the observations that he made. And I don't think he made them lightly. I think he made them from a considered perspective. And I believe he was addressing, a meeting of judges and being very open and frank with them. And again, let's call a spade a spade. He's the national security minister of the NPP government. And what he was pointing out to the judges was that their decisions are seen as favoring the NPP. That's what he was saying. I mean, you put it in very diplomatic terms, but that is exactly what he was saying. And there's been a long pattern as far as this is concerned. We don't need to go back to the election petition of 2021 and all the unanimous FC decisions and so on. But the reality is that as ordinary citizens make these assertions about the judiciary being just, a unanimous football club or whatever, deciding in favor of one side in what they, try to jokingly see as a football match. I think that we are not far away from seeing a situation where people turn their backs onto the whole judicial process. That is what leads to people taking the law into their own hands and not feeling that they can confidently have justice in court. The Mo Ibrahim Index is not something to be taken lightly. They have for years, that index has for years been studying situations like the judiciary status and so on. They've been studying corruption. And the sad thing is that it's not only the Mo Ibrahim Index that has highlighted some of these issues about the perceptions of the judiciary within the population. You've also had, I think it was a UN study about corruption, in which they were looking at various institutions' corruption, and they were talking about Lands Commission, judiciary, amongst the institutions which are perceived, as being, corrupt in the ways in which they function. Now, I think that we need to be very concerned, especially, like I said, if we are legal professionals, if we are the people in those judicial positions. And we all know, I mean, the ANAS investigations and what it led to in terms of, the image of the judiciary. So these issues, and I would dare say, they are not just issues about image. There are also issues about the reality. What is the reality? ANAS uncovered certain real accounts of corrupt practice by judges. And as people say, that was only the tip of the iceberg. So we should be concerned enormously about that. And we should find ways in which to address what is being uncovered through this Mo Ibrahim Index.
Okay, let's talk about SAL now. I mean, SAL has been described as the cardinal sin of the 8th Parliament. And you have been in court for the last 4 years trying to get justice for the people of SAL. Tell us, how did it happen? How did it happen that the people of SAL were not able to vote in 2020 to get a representation?
On the 6th of December, in the afternoon, evening sometime, the Electoral Commission came out with a statement that the people in those areas cannot vote in the parliamentary election. They can only vote in the presidential election. Those people had been part of the GHOne constituency, and basically they were prevented from voting in that constituency. Now, when we took the matter up, the Attorney General's position, initially we took it up in the High Court as a human rights matter because their right to vote, they've been deprived of their right to vote. And we are all aware the right to vote is so fundamental in a democracy. We took it up in the High Court. The High Court granted an injunction ex parte based on the urgency of the situation. And the Attorney General went to the Supreme Court to have that injunction set aside based on the argument that we should not have gone before a human rights court, but we should have gone with an election petition before the High Court. And that is what the Supreme Court decided, that we should have gone by way of an election petition. So we started an election petition. And again, I mean, it's very sad to say some of these things, but it's the truth. Even getting the election petition served on Honorable Amau was a whole issue in itself. A bailiff of the High Court who was actually beaten to pulp, in connection with trying to serve this. But anyway, the main point about why they have not, up till now, been, allowed a correction of the situation is because on the part of the Attorney General, the position was initially taken, and the Attorney General went to Parliament to say this. He said that the people should have voted in the Boem constituency because there was a constitutional instrument which had moved them from GHOne constituency to Boem constituency. So according to the Attorney General, the Boem constituency results, which led to Honorable Kofi Adams being made an MP, should be set aside, and there should be a rerun of Boem, election. Interestingly, again, the Electoral Commission in May this year, in a press release, highlights the fact that it would have been wrong for them to let those voters vote in the Boem constituency. So they are now taking a position contrary to what the electoral, to what the Attorney General is saying. And at the same time, in the whole High Court, they were maintaining that the CI 128, the constitutional instrument which the Attorney General had been relying on, they were maintaining that that CI should rather have been used for the election and not the CI 95, which is the CI under which these people were part of Hohoe constituency. Now, again, simple reality. CI 95 was, put into force in 2016. The Constitution has a clear provision, Article 47.5, which says that you can review the boundaries of an existing constituency after not less than 7 years, or based on a census result and certain conclusions from a census. Now, 2020 was less than 7 years from 2016 when CI 95 came into force. So there was no basis for trying to replace it with CI 128. That's another reason why CI 128 was clearly not in force. But you have a situation where the Electoral Commission, which has publicly stated in May this year in a press release that CI 128 was not really in force, they continue to rely on that CI in the whole High Court. And because of that, the whole High Court said that the issue about the validity of CI 128 is a matter that is not within the High Court's jurisdiction, which of course, again, is wrong based on all the decisions of the Supreme Court, which show clearly that the High Court is where these matters have to be determined. And the High Court should apply the Constitution. There was no dispute about the interpretation of Article 47.5 of the Constitution, so it was very clear. The final point in relation to SAL that you ought to be aware of, people who try to justify the situation about SAL rely on the fact that the SAL areas have been moved into the OT region. And because there's, again, a constitutional provision which says that you can't have a constituency which sits in two regions, therefore, they cannot be part of Hohoe constituency, which is in Volta region. But again, that is simply wrong, because when you look at the constitutional instrument 112, which the president used to create the OT region, the language is straightforward and clear. The language of that provision says, OT region shall comprise the districts specified in the schedule to this instrument. Now, you go to the schedule, the districts are specified, 1, 2, 3, 8. Then in 9, it says Sancho Kofi, Akpafu, Lolobi, Likpe, traditional areas. Those traditional areas, as the Electoral Commission admitted in the case in Ho, were not a district. And they were not part of a district at that time. They were part of the Hohoe municipality. They were not part of a district in the OT region or anything like that. So basically, just interpreting that constitutional instrument which created OT region, South traditional areas are not part of OT region. That's just clear in the language of the instrument.
All right, because of time, what's the update in getting justice for them?
The update is that there is an appeal to the Court of Appeal. We're trying to get the record settled because, from the point of view of the people of Sal and the petitioners that I've been representing, even if it's no longer going to be possible to hold a by-election and correct that obvious, cardinal sin, for the record, it needs to be established that that constituency election was not a valid election. I think for them, it would be at least a measure of justice for that determination to be made in the Court of Appeal.
All right. Finally, on the image of the judiciary, very quickly, the Speaker of Parliament, when he last met the press, said that the executive and the judiciary were working together to frustrate the business of Parliament through some things like what's happening with the anti-gay bill in Parliament and whatnot.
I'm not aware of exactly what the Speaker of Parliament said in relation to, what you are describing, and I don't easily go in for conspiracy theories.
Okay.
So until I know exactly what was being said, I'm not able to comment on that. What I have been insistent on, as you will have heard me emphasize, is that whether it's the executive, whether it's Parliament, whether it's the Supreme Court, we must all be intent on examining their conduct in the light of the Constitution.
All right.
And what the Constitution requires each of them to do. Where they each fall short, they need to be held to account.
But
and they need to be held to account by us, the citizens.
Okay, but what do you make of the president blocking the transition of the bill to him?
Well, again, the rules of Parliament are clear about the processes for bills being sent to the president and so on. If those processes are followed and the president refuses to accept a bill, of course, that's not in line with what the Constitution's clear language requires. But as I say, I don't know the circumstances. And, I don't like to speak out of turn about things that I don't have the full facts on.
That's fine.
In terms of the procedure for bills being sent from Parliament to the president, it's very clear-cut. The president doesn't have a discretion when bills have been, passed by Parliament. He doesn't have a discretion whether to accept or not to accept. He has certain powers in terms of whether he wants a reconsideration and how he can refer matters to Council of State and so on and so forth, and even let it go back to the Parliament for them to reconsider. He has those opportunities, but he can't just refuse, in respect of any bill. So I think that this again emphasizes what I have been highlighting, that all of us must have an interest and must really ensure that no arm of government is putting itself above the Constitution.
Okay.
Because that is the road to tyranny and not democracy.
Okay. My final question before we get a bit personal, I want us to talk about Article 1281 of the Constitution. Currently,
what does it say?
About the minimum number of judges that we can have at the Supreme Court, which is 9, plus the Chief Justice. The Chief Justice, like many predecessors, have said that there's a caseload at the Supreme Court. And so you have cases like the Domelovo case and that of the COVID restrictions, which they eventually ruled were unconstitutional acts by the president. But there was nothing that could have been done about it because the harm has already been done. Will you support a constitutional amendment to increase the ceiling of the number of Supreme Court judges? Because as it stands, we do not have it.
The Supreme Court at the moment, the constitutional provisions do not provide a ceiling, by the way. There's no ceiling. But
the minimum.
Yeah, but I want to go back. The Domelovo case, the reason why it wasn't heard early, I don't think it's caseload. It's not a matter of caseload because there were many other matters that were heard in that time. And if a priority had been placed on that, take this Afenyo Markin's case. Look at the record time in which it was heard, with not even hours. So I think that we must all be clear that these issues about caseload, I mean, I see many judges in the court below, the court, like the High Court, also talk about caseload. I mean, you go to court as a lawyer in a High Court, you see many, lawyers waiting for their cases to be heard, and often it doesn't get to their turn and so on. If we're going to talk about caseload in the court, we've got to take a comprehensive look within the whole court system. And so I don't frankly appreciate this attempt to, make the caseload of the Supreme Court a thing in itself. If we're going to look at caseload, we've got to look at it in terms of the court system globally, and whether we're going to have 24-hour court sittings like the 24-hour economy, or whatever it's going to ensure that there is more, activity in the courts that meets the caseload. But I don't think that one can separate the matter of the Supreme Court. Now, as far as the numbers of judges in the Supreme Court, again, my view is that the Supreme Court, I mean, currently constituted, has probably, I think now about almost 18
judges.
About 18 judges. Now, I mean, again, as lawyers, we observe that when the court is sitting, the court doesn't even sit all days of the week. And when the court is sitting, only a certain number of judges are sitting. So many of the 18 are actually not sitting. And I mean, it's difficult with that to say that they need an increase in the numbers. I know that the Chief Justice proposed, I think sometime in July, that there should be an increase to 20 from the 15 that was conventionally, But fortunately for us, the Judicial Council took a position against that, because the Judicial Council did not feel that even the timing was right. Because in effect, you would have a situation where an outgoing president is making appointments to the Supreme Court, which will put on the Supreme Court judges who will be there until they are 70. And that's being done by an outgoing president. Again, a previous Chief Justice had said, when I think it was President Mahama who had tried to appoint members of the Supreme Court when it was not even yet 15. A previous Chief Justice had said, with this timing, it's getting close to elections, it's better to wait, let the next president come in and make these appointments. But here we have a situation where this Chief Justice, regardless of that previous precedent, was trying to push the Judicial Council into having appointments made. And I say the Chief Justice because she had initiated a memo to the President as far back as in February, in which she was trying to use the caseload justification and so on and so forth. So in the end, the Judicial Council said, no, let's halt. It's close to elections. Let the new president come and consider this. And I think that was the right position that the Judicial Council took. I think it would have looked really, unfair and misused, frankly, of the powers of the president.
So should we put a cap on the number of judges, Supreme Court judges?
I don't think it's necessary to have a formal cap. There are things that people should not require a strict legal sort of instrument or a strict constitutional provision before they go according to them. I think that we sometimes overemphasize what can be achieved through changing the law or reviewing something in the Constitution. Some of the time, the problems we're dealing with are just problems of poor governance by people who have been elected to certain offices or have been appointed to certain offices and who are expected to use their judgment in ways that are beneficial to the national interest. If they don't do that, it's not the law that is at fault. It's not the provisions in the Constitution that are at fault. It is the people. We should hold them accountable. That should be our first point of reference. Of course, there are things that may require modification and so on in the Constitution, and there's been a whole review committee set up, and they've come up with recommendations which, have still not been really looked at closely. But I think sometimes these arguments about Constitution being reviewed and so on, they make us lose sight of the sheer failures of leaders to do the right thing in the interest of the nation, in the interest of the people. I think we should really hold leaders accountable for doing the right thing. And, it's not enough just to say the president has too much power in the Constitution, so let's limit their power. What is it that you believe they've done wrong in terms of their misuse of power? Let's address that and hold them to account that you are misusing your power in this way. You said e-levy is going to rake in so much, and it hasn't. Let's hold you accountable. And on account of that, a whole constituency was deprived of having its member of parliament operate as a member of parliament for several months. And a by-election was eventually held and so on. Let's hold people accountable for their failures of leadership.
All right. Speaking of holding leaders accountable, I've been talking with Mr. Tsatsu Tsikata. We have just about 5 minutes to wrap up the conversation. Let's get a bit personal. It's less than 30 days to the general election. Who are you voting for and why?
Well, since you asked me on national television who I'm voting for, I am voting for John Mahama. And I'm voting for John Mahama because I think the clear failures of the current government and the depths to which we have sunk, not only in terms of our economy, but also in terms of governance, are such that it is really hard to justify voting for somebody who, as vice president, has been so deeply involved, particularly in the issues of the economy. On the other hand, I think that in respect of President Mahama, yes, he has had a previous term in which I think his performance was certainly a lot better than the performance that we've seen over the last 4 years. So I don't have any doubt about that. But there is more to my decision. But I don't also want people to see it as just voting for my clients in the last election petition, because it's not about that. Frankly, when I'm involved in election petitions, I see them as going beyond even my clients. I see them in terms of the issues for the nation. And I hope it's in that sense that the answer that I've been given will be understood.
Have you forgiven former President Kufuor?
Forgiven? There is nothing to forgive. In fact, you know what? You asked me this as the last question. I say to people that I never had any bitterness or any feeling of great grievance against President Kufuor. He did atrocious things against me personally for whatever reason. He was determined to have me in prison, and I did go to prison, orchestrated by him, on June 18th, 2008, for 5 months. By God's grace, I didn't die in prison. I was evacuated to hospital, and by God's grace, I'm still alive. Now, he tried the last day of office to offer me a pardon. I rejected it because it was in bad faith. It was clearly in bad faith. He had orchestrated everything. The day that I was being sentenced, the court had not even announced that it was going to give a decision at the end of the trial, because the trial hadn't ended. There was something in the Supreme Court which needed to come back to the, all that was of no account. It had been set up for me to go to jail that day. I went to jail, and you know what? I actually thank God for that experience. I say to people that going to that Nsawam prison took me to another university, another faculty of law, because I engaged with many of those who were in the prison, and I realized that there were other people suffering injustices, you know, and who didn't have the kind of recourse that I had. I had the opportunity of a lawyer, a close friend of mine from my Legon days, who, you know, gave his all to stand up for my rights. A lot of those people didn't even have, I saw people who'd been in jail for 12 years. Nobody had gone to court on their behalf. So I counted myself privileged. And what is even more exciting, you know, on my first Sunday in that prison at Nsawam, when I went to the church, there was a pastor from Asamankesi who came to preach. And he used as his text Genesis 50:20. That was where Joseph is saying to his brothers, you meant it for evil, but God meant it for good.
Right.
And then he also used Romans 8:18, you know. I mean, basically, whatever suffering it was meant to be for me,
It didn't turn out
in
that way.
the end, it didn't turn out like that.
All right.
In the end, you know, and my wife and I always say that we were on a spiritual high during my months in prison.
Okay. All right. We'll use the last 3 minutes to talk about music, since your son is a musician.
But let me add one thing.
Okay.
You talked about President Kufuor and my imprisonment. You know, we really sometimes. I mean, I've met President Kufuor on a few occasions since, and I mean, usually it's been in the company of my wife, and it's, you know, we've extended courtesies. I think I once ran into him. I was on a flight, I think it was South African Airlines. He was there, and as I went to my seat, I shook his hand and so on. You know, I really don't bear a grudge on account of what happened.
Okay.
But I still would hope that there are lessons learned, because I used to share with President Mills that I don't want what happened to me to happen to anybody in the NPP under him. Because President Mills, had exactly the same position. He said, look, I am not going to misuse my position to go after people that are seen as on the other side. And for me, that perspective of President Mills is something that we should all learn from. You know,
Okay.
we really, he set us a huge example of leadership. And I wish some of the people who were even his contemporaries in Legon in those days would learn from his example. I mean, he didn't try to set up a statue in his own commemoration, even though, you know, he did so much for this country.
Okay. Finally, Mr. Tsikata,
My son,
M.anifest or Sarkodie?
You know what? You are trying to trap me, but I'll give you my answer. M.anifest and Sarkodie actually did a collabo, brown paper bag.
Yeah, oh, you know it.
And so, you know what? I enjoy both of them, but of course, more of the time, I'm enjoying my son than anybody else.
So you think
because he's
M.anifest
my
is a
son.
better musician?
I didn't say that.
Wait, who's your favorite musician aside your son?
Don't put words.
Who's your
into
favorite
my
musician
mouth.
aside your son?
You know, I'm not going to get into that, because
Aside your son?
I can see that you are really trying very hard to set me up
Not at all.
against Sarkodie.
No. I mean, so aside your son, who do you think is really good?
Sarkodie.
You don't know Shatawale?
You know, I'm not going to get into my likes and dislikes in music.
Thank you very much, Mr. Tsatsu Tsikata, venerable lawyer. Mr. Tsatsu Tsikata, how long have you been practicing?
Since 75. Next year will be 50 years.
Oh, my goodness. Thank you very much for coming on the show. It's been a great pleasure. Thank you very much for watching Heart Talk.